On the 6th of April 2007, the Tenancy Deposit Scheme requirements under the Housing Act 2004 came into force. These requirements apply to all assured short-hold tenancy agreements, and they also apply to all tenancy deposits paid before, on or after the 6th of April 2007 in connection with an assured short-hold tenancy agreement. The Tenancy Deposit Scheme requirements set out that a landlord must protect a tenancy deposit with a government authorised scheme within 30 days of the tenancy deposit having been paid. The landlord must also provide the tenant with something called the prescribed information within 30 days of the tenancy deposit having been paid. And the last requirement is that where a relevant party, which is defined in the Housing Act 2004 as being a third party that paid part or all of the tenancy deposit on the tenant's behalf, they must be given the prescribed information also within 30 days of the tenancy deposit having been paid. Now, these requirements must be complied with, and there are consequences landlords could face if these requirements are not met. The Tenancy Deposit Scheme only applies where a tenancy deposit has been paid in connection with an assured short-hold tenancy agreement. There is no requirement in law that landlords must take a tenancy deposit. If no deposit has been paid, the Tenancy Deposit Scheme does not apply. There are two consequences where landlords fail to comply with the Tenancy Deposit Scheme requirements. The first is that no Section 21 notice can be served on the tenant where the landlord has breached any of their obligations in relation to the Tenancy Deposit Scheme requirements. Unfortunately, the only way to lift this restriction on serving the Section 21 notice is to return the tenancy deposit in full to the tenant or relevant party. That would then lift the restriction on serving the Section 21 notice, which is also known as Form 6A, or the no-fault ground for possession. It's an important ground for landlords, as it's the right that a landlord has to terminate the tenancy without giving a reason. Another method that could be available to landlords in the case of rent arrears, damage to the let premises, or other sums owed by the tenant to the landlord is for the landlord to seek to agree with the tenant, preferably in writing, that the tenancy deposit is to be used in full against the outstanding rent, against the damages, or whatever sum may be lawfully due by the tenant. If that is agreed, and that results in the tenancy deposit no longer being held by the landlord, as it's been used in full to offset outstanding rent, damage, or any other sums lawfully due, that could also lift the restriction on serving notice. I would urge you to seek legal advice from our legal team on that point if that is a method that you may wish to pursue. The other consequence a landlord could face is a penalty between 1 to 3 times the value of the tenancy deposit where a breach of the Tenancy Deposit Scheme requirements has been made. A tenant or a relevant party could bring a claim against a landlord to seek 1 to 3 times the value of the tenancy deposit. Now, there can be defences or mitigating factors to such a claim, and we've dealt with that in a separate video, and the link for that video is in the description below. There are only 3 tenancy deposit schemes available that are government authorised, and they are the DPS, the TDS and My Deposits, and we have included a link to all of those 3 government authorised tenancy deposit schemes in the description below. If you do require any legal advice on compliance with the Tenancy Deposit Scheme, or if you have received a claim seeking a penalty for non-compliance with the Tenancy Deposit Scheme, do contact our legal team and we will be able to assist you.